Good morning and welcome to what we hope will be an interesting and informative fireside discussion about interventions in financial remedy proceedings. I say fireside because winter is now very much here. We look out the window and see the rain and wind lashing against the windows. But the practice and procedure in this area is incredibly important because not only can it be extremely expensive if it goes wrong, but it can also rip families apart, as often the third party who's joined into these proceedings is related to one or other of the spouses. It's also worth bearing in mind that the risk doesn't just fall at the litigant's door. We know that one of the leading cases in this area is the case of Fisher Meredith and J&H and P&H, brackets financial remedy appeal, wasted costs. And just the name of this makes it clear that there are risks to practitioners if you get the procedure wrong. We're joined today by a hugely experienced panel. We have at the far right of the table, Aasha Choudhary from Mills and Reeve. Next to me, Mark Hands from Irwin Mitchell, and to my left, St Philips's very own Leisha Bond. Between us, we have over 70 years of experience in dealing with cases like that. Obviously, there's a spectrum of ages, which gets higher and higher as you come down this end of the table. Anyway, I'm going to kick this discussion off by asking Leisha why anyone would want to join into financial remedy proceedings anyway.
Well, when you and Mark are in court, you obviously have a lot of fun, apart from when you're bickering. Aisha and I always have a lot of fun. When we're against each other, it's generally car crash litigation, but we have a hoot. So wanting to come and join our party is understandable. Clients always prefer taking advice off friends and family rather than the lawyers, so they can take advice from them easier. And also, and this is probably the answer you were expecting, is when binding decisions are made about properties that third parties claim they have an interest in, then those third parties have to be given an opportunity to engage in the litigation. This all goes back to the late great Lord Denning in Gertner and Circuit, which was a case that was so long ago, even I wasn't born, despite my huge age. Thank you, Jonathan. So this is a 1968 case, and it involved precisely the importance of involving third parties in litigation. In that case, it concerned the Motor Insurers Bureau. And he said the Motor Insurers Bureau were vitally concerned in the outcome of the action. They are directly affected, not only in their legal rights, but also in their pocket. They ought to be allowed to come in as defendants. It would be most unjust if they were bound to stand idly by watching the plaintiff get judgment against the defendant without saying a word when they are the people who have to foot the bill. He considered the issue of joinder again later in his career, where the issue was directly relevant to the distribution of assets on divorce. And this was a claim under the 1973 Act for a transfer of property. There was an intervenor called Mrs. Tebbett, and she claimed that the property in dispute was one that she had an interest in. And Lord Denning said, it seems to me that under the 1973 Act, if an intervenor comes in making a claim for the property, then it's within the jurisdiction for the judge to decide on the validity of the intervenor's claim. The judge ought to decide what are the rights and interests of all parties, not only of the intervenor, but of the husband and wife respectively in the property. He can only make an order for transfer to the wife of the property, which is the husband's property. He cannot make an order for transfer to the wife of someone else's interest. So in order to make an order under Section 24, it must be within the jurisdiction of the judge to determine what are the various rights and interests in the property, not only of the husband and wife, but also of any other person who claim an interest. So that's this kind of legal background. So if there's a claim that some property in dispute in a divorce actually belongs to someone other than the legal owner, then the purported beneficial owner is going to want to come to our party. But I think the question I'm going to shoot down to the end is, what principles should be used when looking at third party interest when couples are divorcing?
Well, you have to remember, sorry, my throat's sore, that where there are third party rights, the relevant law must be applied. So it will usually be under relevant established legal principles of civil law. And the main areas of law that are applied are company law, where there's the corporate veil and there's a limited company being a separate legal entity. Trust law, so constructive and resulting trusts, and the proprietary estoppel, and also land law, where the focus is on who owns the legal title and where there is any declaration of trust. Now, this was very well summarised by Mr. Justice in Ben Hashim, which is a 2008 case, where he said, even in family division, a spouse who seeks to extend her claim for ancillary relief to assets which appear to be in the hands of someone other than her husband must identify, and by reference to established principle, some proper basis for doing so. The court cannot grant relief merely because the husband's arrangements appear to be artificial or even dodgy. The family division applies precisely the same principles and in precisely the same way as the Chancery division, or for that matter, the Queen's Bench division. So it will be the relevant law that applies. It's not that just because these proceedings are family law proceedings that there's a different law that's applied. So as I said, it's company law, trust law, land law mainly.
And what we'll come on to look at in a moment is it doesn't just apply to the law, but it also applies to the procedure that's involved. So when you come into this, you very much have to have your civil hat on. You have to think about putting your case early in a letter before claim, setting out the relevant civil law principles, and not simply rely on the type of palm-tree justice that we might get in the family court.
So the question for Mark is, what sorts of circumstances are people joined in?
The relevant rule, and you're pleased to know I'm not going to laboriously read it out, is Family Procedural 9.26b. I'm going to really, what we're looking at is the classic example of where an asset is held by a third party. So, for example, you might have the sister of a husband who holds shares which the wife say belong to the husband, or where you have a property where it's been held by usually a third party family member. Now, I do a lot of cases in the context of intervenor Asian disputes where culturally family members hold assets on behalf of the parties. That's how they deal with their culture. So it's very important, actually, and I say this, I express some caution. It's very important for you to look at whether there is actually a dispute, because I had a case recently where, bizarrely, the family home was held by the husband's brother, and the husband's brother's family home was held by the husband. But there was no dispute. They were legally held by the other brothers, but there was no dispute. It's beneficial interest. It was not necessary to join that part into the proceedings because they all agree how the beneficial interest is held. So those are what I would call the classic examples. I'd just caution again in terms of, I hope I'm not getting overly technical with this, but the section 37 test in terms of setting aside a transaction. You have to establish that the transaction has the effect or the intention to defeat claims. That's not necessarily the test here. So be careful to draw a distinction between the two. And then the other two, which I think are less obvious, and one I think solicitors grapple with more than actually perhaps counsel at the time, because we're perhaps at the coal face, there might be disputed, of making these decisions. But it's also the concept of a loan. What do you do with a loan? Because a loan is a loan, it's not an interest in the asset. So somebody may say, well, I owe my mum, as I did in a recent case, £200,000. What do you do with that? Because on one analysis, if you're trying to dilute the loan or you're trying to keep it under the agenda of the judge, you don't really want that third party into the proceedings if you're acting for the person who is saying that the loan is not repayable. But then, of course, you'll be met with arguments that it can be dealt with as part of the Section 25 analysis, part of with a witness statement. In my opinion, so in my view, I think it depends on the value of the loan, the extent of the dispute, because really you want to have that person's voice heard. It's very important to grapple that question. And I'll just bore you with one little story I've got about a loan agreement, which is Jonathan and I represented a wife. The husband, during the course of the proceedings and the replies to questions, produced a loan agreement saying that he owed his mum £100,000. The loan agreement was dated 2004, can't remember the precise date. Unfortunately, it was drafted in Calibra font, which didn't come out until 2007. So he had a bit of a tricky one. And Jonathan actually had some fun. I said to him on the day, didn't I, Jonathan, what are you going to do with this? He said, oh, I'll just drop it in just before the hearing. So a Bolshe barrister turned up for the husband, telling us we've been disproportionately running this litigation. Jonathan listened to him for about 30 minutes and then turned around and said, I do have this report I'm just going to hand to you about font. We've got a font expert. I don't know how we got a font. I didn't know we've got a font expert. Handed it to the barrister and Jonathan said, do you want to go take instructions? And the barrister came back and said, yeah, we'll agree to your position. Not surprising. And then finally, there are other things. Don't just look at the ownership of assets. I did find a case, I was looking this up yesterday, in which a party to the proceedings can actually ask the family court to be joined into a case if they've been unfairly criticised in a judgment, and that was a case of RB, the County Court of Manchester. So it's not just about ownership of assets. And then finally, the issue of trusts. I think that's a very difficult question to grapple with, Jonathan, and we've done a number of those cases over the years. And I mean, what circumstances do you think that's generally inappropriate or unnecessary?
Well, I think that looking at when it's not appropriate to join in a party, we need to look at the practicalities of the situation. So first of all, when the amounts are small, even if you've got a cast iron case in respect to the beneficial ownership of an asset held by a third party, if it's going to make no difference, then there's no point joining them in. So if the property has equity of £50,000 and the overall assets are 5 million, then obviously it would be disproportionate and frankly pointless. And the other situation where it's not worth joining a party in is where your client can't bear the costs and consequences of losing. If the third parties have deep pockets and your client doesn't, then you need to think quite carefully about whether you want to expose them to that risk. It can work the other way around, of course, as well. If you join in third parties who are impecunious, and you run a case against them and you're thinking you're going to get your costs at the end, well, of course, you won't be able to if they don't have the money for you to recover against. But turning to some more technical things, there's the issue of whether you should join trustees in a variation of trust case. And certainly the old view, going back to the 90s, and the key authority was T versus T, which was a decision of Mr. Justice Wilson, as he then was that you should always join in trustees when you're looking at a variation of trust case. And what Mr. Justice Wilson said in that case was that the essential reasons were so that you could achieve disclosure from them, and secondly, so you could enforce any order of the court. To my mind, and apparently to the mind of Mr. Justice Mostyn, as he set out in the case of DR and GR, which was a 2013 case, it's not essential to join in trustees. And thinking about it, if you take those two things of disclosure and enforcement, both of those things can be dealt with in a more cost-effective way. Taking disclosure, first of all, one's target for disclosure in the first instance in a trust case should be the spouse who's the beneficiary. Because beneficiaries, as we know, have extensive rights to documents in their position as beneficiaries. And there could be another fireside discussion about where those rights arise from and exactly what they are. But their rights are extensive. Secondly, if that doesn't work, of course, you could make an application for third-party disclosure against the third party, against the third-party trustee, which would be substantially cheaper than joining them in. The other thing you can do is for the parties, the two spouses, to make a joint approach to the trustees for disclosure with a backup in perhaps the FDA order, where the court invites the trustees to cooperate with that request for disclosure. And certainly if you're dealing with certainly if you're dealing with trustees outside of the jurisdiction, that's often the best way to deal with it. So far as enforcement is concerned, frankly, the most straightforward way to deal with that is to go to court, run it through to a final hearing or an FDR, get your order, and leave your application for a variation of trust order open. And then you can see if the husband pays, and I say the husband, could be the wife, the husband or wife pays. If they don't, then you can bring back your application to vary the trust. So that's a cheap and proportionate way of dealing with it. There is some debate as to whether child beneficiaries always have to be joined. And as I read the rules, they do, unless it can be shown that they won't be adversely prejudiced by any order made. And frankly, it's very difficult to see when that would be the case. The key point in respect of trustees and joinder, frankly, is to make sure you serve them at the start of the proceedings under Rule 913(1)A. That's the key thing. Finally, on the issue of when it's not appropriate to join, I wish to draw your attention to the case of Perber and Perber, which is a decision of Lord Justice Thorpe going back to 2000. And basically in that case, what happened is that there was criticisms of the lower court, who was, in fact, Mr. Justice Wilson, who we were just talking about, and the applicant's lawyers for failing to make an application to set aside a transaction which simply dealt with the husband transferring money from his bank account to a family member's bank account. And what Lord Justice Wilson said in that case was, look, don't worry too much about the technicalities. The question is whose money is it? And it doesn't really matter whether it's sitting in the husband's account or it's sitting in someone else's account. If it's his money, it's his money. So that is a useful get out of jail free card if you haven't joined someone in. But what I would say about that, and the problem with it, is if that third party holding the bank account isn't joined in, they're not going to be bound by any decision of the court, and enforcement against that money will be difficult. So it's only an appropriate route to take when you're offsetting that money against other assets.
Jonathan, just on the point about, I promise this isn't scripted, but the position regarding a nuptial trust, you know, do you think you've got to get the basics right in terms of establishing that there's a nuptial trust first and foremost, and it's therefore capable of variation? Because you can sometimes often have those situations where you have assets that have been acquired by a trust that was set up not in contemplation of the marriage. And do you think that that's, because we've seen that quite often, haven't we, where, you know, that argument's been ventilated. And of course, you know, the point about the fact that a trust once nuptialised can't be denuptialised. And do you think that's quite an important point when you look at those issues?
I think it's important to get the building blocks in first. There's very little point relying on a variation of settlement argument in circumstances where the court simply doesn't have the power to do it because it's not been nuptialised in any way. But what I'd like to know now, Leisha, is who should take responsibility for joining in third parties?
Well, in the best traditions of the law, there's no simple answer to that. It depends. Pursuant to Rule 1.3 FPR 2010, both parties have got a duty to assist the court to further the overriding objective. So arguably, both parties have some responsibility to consider the issue of joinder in the appropriate case. The issue arose in Fisher Meredith, that Jonathan referred to earlier, and Mr. Justice Mostyn set out guidance, as he loves to do, regarding which party has the onus on their shoulders. And I'll read what he said, because clearly he can say it better than me. He said, in my judgment, there is a clear distinction to be drawn between the state of affairs where a claimant is saying that a property is held in the name of a third party. Sorry, where the property held in the name of a third party is the property of the respondent, and the situation where the respondent says the property to which he has legal title is beneficially owned by a third party. In the former case, so that's where we're saying the third party holds something that's actually X's. There's a clear obligation on the claimant to apply to join the third party at an early stage and to seek to invoke the discipline in TL versus ML. Only in this way can the pool of assets over which the dispositive powers of the court ranges be established and an effective FDR take place. In the latter situation, which is where typically the husband's saying it's in my name, but actually it belongs to my brother. The duties are by no means so clear. If an asset is, say, in the name of the respondent, husband, then in my judgment, in the name of the respondent husband, then in my judgment, the starting point of the prima facie position is that it belongs to him both legally and beneficially. He then gave some examples which are quite helpful. He said, let's say there are assets worth £500,000 in the names of the parties about which there is no dispute that they are beneficially owned by the parties. So that's pool A. And a further 500,000 of assets in the name of the respondent, but which he says is owned by his uncle. So that's pool B. The claimant might take the view that she's not going to go to the expense of joining the uncle, but will rather argue in reliance on the starting point in a trial between her and the respondent alone that pool B beneficially belongs to him. Assume further that the uncle doesn't exercise his undoubted rights to apply to intervene. The court is obliged to decide in the exercise of its statutory function which assets belong to the respondent. It decides on the evidence, giving due weight to the starting point that pool B belongs to him alone, and awards all of pool A to the claimant on the application of the equal sharing principle. Certainly the finding that pool B belongs to the respondent doesn't bind the uncle, but it certainly binds the respondent. The claimant can collect a full award from pool A without any difficulties involving the uncle. So this is what Jonathan was just saying, that in terms of enforceability, you couldn't go against the uncle if he wasn't an intervener, but actually we've got enough money just to go against the husband. And from the wife's perspective, that doesn't matter, although it would be pretty unthinkable, I think, if husband joined the uncle. So there's no reason for the claimant to join the uncle in that case. But if we change the facts and we have pool A, the joint money, being 100,000, and pool B, the money that husband says it's not really mine, it's my uncle's, being 900,000. If the court awards 500,000 to wife, she can go after the 100,000 from pool A, but she'd have to enforce the other 400,000 against pool B. And in enforcement proceedings, a claim by the uncle that he owns beneficially pool B is going to lead to problems, although of course in those proceedings the uncle would have to answer the very hard question why he never sought to intervene in the original proceedings. But the wife wouldn't be under any obligation to do so. So in a nutshell, if the assets are in the name of the respondent, but he claims they're beneficially owned by a third party, then really it's on him to join that party. The applicant can sit back if she wants to. But if it's the wife's case that a third party acts as a nominee for the respondent, then it's her duty to seek directions. So if you're asserting that the beneficial interest doesn't follow the legal title, you probably should invite the interveners to the party, unless it's simply not proportionate, because there's a lot more money in the pot than what the third party interests are said to be. So it depends, but basically if you're saying the legal title and the beneficial title are different, you should probably be applying to do the joining.
I think that's an interesting point about the enforcement point though, Leisha, because I think that is a thorny question to grapple with on the proportionality point, because the Baber Harney, always get the pronunciation wrong. That case was one where they made findings that assets held by a third party were actually belonging to the husband, but they weren't joined in. And I agree with you, I think the proper approach is to join people in. But I think there is some authority there to say that this can be grappled with at enforcement stage if all else fails. But I would certainly, if you're going to that point, get to a position where that you thought about that strategy, you've made a conscious decision to deploy that strategy. Don't think about it as an afterthought, oh God, what am I going to do now? So I think that's quite an interesting point about the enforcement point.
I think that's right. If you're going to have to enforce, my view is you might as well get your ducks in a row and get it started. at the right time, because there's no point in getting an order that's been very expensive to get if then actually you can't enforce it and then you run into problems in enforcement.
Yeah.
So I think if you've got an issue, you need to invite people to the party at early doors, and if they then elect not to come to the party, well, the lookout's very much on them then.
So the message really is that each case is different and each case requires thought and a different strategy, perhaps.
Yes. So tell us the test for inviting interveners to our party.
The test is really straightforward. It's set out in Rule 9.26b, and it's as follows. So it is desirable to add the new party so that the court can resolve all the matters in dispute in the proceedings, or there is an issue involving the new party and an existing party which is connected to the matters in dispute in the proceedings, and it is desirable to add the new party so that the court can resolve that issue. God, that's a mouthful. Conversely, it is also worth remembering that the court may direct any person or body to be removed from the proceedings as well as being added if it's not desirable for that person or body to be a party to the proceedings. But as I said, it's a straightforward test and the threshold is really low. And once we've added a party, what we need to think about is what directions the court might make. So, Mark, what directions should or could the court make?
Well, I think, my message would be get your basics right first. So I know it sounds really basic, but do your D11, attach your order, tell the court what orders you're asking them to make. Perhaps sometimes less is more in those applications, but once you've set it out and you allow counsels to go and do their thing at the FDA, really we're looking at a situation which, Leisha, you touched upon at TLBML, and that really sets out a roadmap in terms of pleading the case, followed by disclosure, followed by statements, and then a preliminary hearing. I just wanted to mention just a couple of tactical points really, which you may or may not find helpful. But really looking at standard disclosure, don't look at it through the lens of a family lawyer, look at it through the lens of a civil practitioner, because actually there is a duty, really should be the same duty, but I think family lawyers tend to just put forward evidence that's favourable to their case in their witness statement. But of course, from a civil perspective, you've got a duty to put forward any material that's favourable or adverse to your case. And I think it's, probably speaking a bit loosely here, but I think it's much more strictly applied in civil proceedings. And therefore, in my experience, the best way of doing this is to make your client completely aware, is to get them to put another hat on and send them a Rolls-Royce advice letter, but something that's very plain about what their duties are. And I think that's also good for your file from an insurance perspective to have that on there. And really then looking at what I would say is one other thing I've seen quite commonly where perhaps sometimes we get invited to intervene after the directions have been made because the third party's joined and then they need a solicitor. So we have a look at the directions. And one of the issues I often see is that it's an inadequate time estimate. So if you think about the family law procedure, that might take, a standard application 9 to 12 months. You're pressing pause on that procedure and you're embarking upon a new track, which in itself could take another 6, 7, 8, 9, 10 months. The last thing you want is for that preliminary hearing to go part heard and that then be delayed for another 3 or 4 or 5 months or 6 months. So very important to get the proper time estimate, but also insist on a PTR, which is not necessarily in the TLBML directions, but insist on a PTR so that you can make sure the case is in perfect order and it's ready to be contested. And then one final thing I would say is give some very serious thought as to what witnesses you're going to require, because often they're broader in these types of disputes than they are where you have a husband and wife scenario. And it may be that somebody in the company can provide good evidence as to the actual ownership of those shares. Think about all of those kind of broader issues and who might actually have some key evidence to kind of, help you establish issues that you're trying to get the court to determine. But there are circumstances, and I can't stress this enough, that TL and ML should not be followed. And Jonathan, I think it's the Mumby decision in A&A where they say, they go on about that. But I mean, you and I grapple with this issue quite regularly. When do you think that TL and ML shouldn't be applied? And I have to say, I've seen you argue this quite persuasively both ways, depending on which side of the table you're sitting on. So what's your view on that?
Well, there's a difference between whether someone should be joined and whether TL and ML directions should be slavishly applied. And it's a question, to my mind, of proportionality. Now, many people come before the court and say the court has to apply TL and ML directions. That's not the case. Mr. Justice Mumby in A&A said this, referring to Mr. Justice Mostyn. He then went on to say, I'm sympathetic to the approach being suggested by the deputy judge, that's the TL and ML discipline, though I would not wish to be quite so prescriptive as he appears to be. Vigorous case management in these cases is vital, but the appropriate directions to be given in any particular case must reflect the case managing judge's appraisal of the forensic realities of the particular case and the best, most just and effective and expeditious way of resolving the matter. So I think what I would say is this, that sometimes having full TL and ML directions is disproportionate and expensive, because what you're factoring in is not only the delay that Mark just referred to, but also that additional preliminary hearing. Secondly, it used to be said, well, you can't have an FDR until you know what the assets are, and the court can't give indications on disputed issues like beneficial ownership of property. Well, of course, that's not true, because if you run a case through the Chancery Division, certainly in Birmingham, the court will list the case for an FDR. And so if they're dealing with FDRs and having them in Chancery proceedings, they can certainly have them in intervention proceedings. So in some cases, not every case, but in some cases, I would suggest that the parties should set out their cases in pleading so that everyone knows where they are, and then have your FDR and consider how the third parties can be factored into a deal which can be done to resolve all issues. Just on the issue of TL and ML directions generally, I think that people can save themselves a lot of bother if they set out in a letter before claim, before they issue proceedings, what they're seeking against the third party. Then when the TL and ML type application is made, it comes as no surprise to them. They're some way down the road, perhaps they've already got some representation on board, and you can save some time and expense that way. The other thing in respect of disclosure is to ensure that not only is there an order for disclosure, but there's an order that the parties providing disclosure sign up to a disclosure statement. So they have to sign a statement of truth setting out that they have provided all documents that either advance or undermine their case, because then that will focus on their strict obligations. So, and I ask this to everyone really, moving on, is what common issues arise in financial remedy proceedings involving third parties?
Well, it's certainly my least favourite topic when I did my degree those thousands of years ago. Trust law, the beneficial ownership of property, where just the phrase would bring me out in hives. Stack and Dowden, Baroness Hale sets out very nicely that effectively the starting point where we've got sole legal ownership is sole beneficial interest. The starting point where there's joint legal ownership is joint beneficial ownership. So the onus is on the person who's trying to show that the beneficial ownership is different from the legal ownership. And we're looking predominantly at three different sorts of trusts. There's an express trust, which tends to be not the most common thing we're dealing with, because when there's an express trust, that tends to be the start and the end of it. So that's where a person either expressly declares that he or she owns property on trust for another, or he or she transfers the property to another expressly subject to a trust. You don't need any particular words to create a trust, but it's usually pretty clear that a trust's being created. The trust document doesn't need to be in a deed. Documents signed by the trustees will suffice. And an express declaration of trust, absent fraud or mistake, will end matters, and that's the case of Goodman and Gallant in 1986. So that's why before you give any advice at all on ownership, you should ask to see the TR1, because sometimes that concludes that if you tick the box where beneficially joint tenants or where beneficially tenants in common 40/60 or whatever, then it's game over unless there's fraud or mistake. I've only had one case go to trial where there was an express ticking of the TR1 beneficial interest box. Somewhat bizarrely, the TR1 form hadn't been asked for. At the PTR, I suggested, or rather after the PTR, I was then instructed, and I suggested to my solicitors it might be a really top idea to get the TR1 form. I was handed it on the morning of day one of the final hearing, and the beneficial interest tick box was signed with a certain percentage to my client. That wasn't actually a percentage I was arguing for, but it was better. So I thought, that's great, let's roll with this. So I went off waving the TR1 form to my opponent, who said, well, that's just a mistake, that's ridiculous. So I obviously did a very dramatic stage sign, flounced off. My client then arrived, I took her through it, and she said not only was it a mistake, but it wasn't her signature. So we settled that. But generally speaking, if you've got the beneficial interest box on the TR1 form, that's an end of it. What we normally deal with, of course, is constructive trust, which is where a trust is implied to give effect to the common intention of people. So you've got an agreement or an understanding that we hold this property in this way beneficially, and in reliance on that agreement or understanding, the other party, the person with the beneficial interest, will go and act to their detriment. We very often run resulting trusts in the alternative, but in my experience, really, that's always just the fallback position. So that's an implied or presumed trust where a person makes a direct financial contribution to the purchase of a property in the other's name. The contribution has to be at the time the property is purchased, but certainly if you're running resulting trust, I think you probably, certainly I've never run resulting trust without having constructive trust as sort of my first position. We've then got proprietary estoppel as the fallback position, really, which is where a person's been encouraged or allowed to believe by an owner of the land that he or she has certain rights in or over the land, and then they act to their detriment. So it's very similar to a constructive trust, but we don't have this meeting of the minds, and it's where it's unconscionable for the owner to deny the claimant rights over the land. But the relief that the court will grant in these circumstances may or may not be a grant of interest in property. It's really the least you can do to do some vague justice to the case, but it's really your catch-all last-ditch attempt to salvage something.
Leisha, the point about the resulting trust, which I think actually we've got Andrew Donaldson in the room that you won't see from the screen, but he'll be pleased from a legal purist point of view. I always try and remind people of decision in press, really, which did concern properties being held by company structure. And what the Supreme Court said was actually you can't just ride roughshod over the resulting trust principles. And actually, in that case, they found that these properties were held on a resulting trust for the husband because the husband had paid for them. So from an accountant's perspective, I suppose one has to be very mindful that even if when them companies are set up and assets are acquired, there may not be any contemplation of a divorce at that stage, but there may be in 10 years' time. And we look back at the files and see who paid for the assets. And you know, really, I suppose from an accountant's perspective, it perhaps be prudent to have a family lawyer's perspective on setting these kind of structures up to make sure that they, you know, that you can minimise the extent to which they can be infiltrated, so to speak. So I think the resulting trust, I take your point on that issue, but I think where the money, if you follow the money and the money goes into these properties, then you've got a case, in my opinion. And the constructive trust is obviously the gold standard, but that's the way I would see it. And Aasha was speaking to me before we come on about the one case you had about challenging a declaration of trust.
Yes.
And again, that wasn't scripted. You were telling me before we
No.
come on. But yeah.
I acted for a husband in that case, and there was a declaration of trust regarding ownership of shares in a company. And the declaration of trust itself predated the incorporation of the company, which is not a problem. But the issue arose because the declaration of trust then went on to record the registration of the company. So clearly there was some dodgy dealings going on there. And it's just one of many examples of where, you know, paperwork will get people into trouble, where they kind of try and post date, sort things out for themselves.
I mean, the message that comes across very clearly from that is look at the document very, very carefully. Another example that I had was a declaration of trust, which was dated in 1989. And on the declaration of trust were the details of the solicitors and their telephone number. It was an outer London firm of solicitors, and they had the telephone number down as 0208. Now, of course, 0208 didn't come out until much later, and at the time, the number would have been 01 or 0181. So it's really important to look at every little bit of these documents. And that brings me on to the other thing that I was just going to mention very briefly that arises commonly in these proceedings, and that's the issue of sham. And the leading case in the case of sham is the beautifully titled Snook and London West Riding Investments. And in that case, the principles are set out clearly. And it talks about a document being a sham if it's intended to give third parties or the court the appearance of creating between the parties legal rights and obligations different from their actual legal rights and obligations, which the parties intend to create. So it's all a question of intention. And there is a useful, very useful summary of the law, again by Mr. Justice Mostyn in the case of Borough and Borough, which is a 2014 case. Now, I'm conscious of the time, now 17 minutes past 9.
Jonathan, just on the point of the sham and the trust, I think it's important to, we all go over this as well, is that the trust itself cannot be a sham, it's the document that's the sham, isn't it? So the sham trust arises from the document itself. And that's important to plead that properly.
Yes, it comes from the intention of the people who create the document.
Yeah.
Moving on then to our final topic, and I'm going to pose this final question to Aasha, and it's this really. How are costs dealt with in these intervention cases?
Well, costs are dealt with differently in intervention cases, and I think costs are the most stressful part of most cases, and certainly keep me up at night, even more so with intervenor proceedings, because you know the stakes are so much higher. So the no order for cost principle doesn't apply to intervenor cases, but nor does the civil procedure rule, which is costs follow the event. So this is kind of a hybrid principle that applies, and it's completely discretionary for the court. And the case of M&M summarises the cost position for intervenor cases very, very neatly. So I will read from there for you. And there's a quote by Mrs. Justice King in her judgment in M&M, where she says, Mr. Wagstaff QC appeared to represent the 3 companies supported by the usual cast of characters appearing in such cases, including junior counsel, senior partner from Withers, at least one associate solicitor, and various others whose precise role is unclear. The only person Mr. Wagstaff had missing from his entourage was a human client. The directors of the companies he represented were as elusive as the husband. They never filed a statement nor attended court to give evidence and would be cross-examined. And in considering the issue of costs against husband, Mrs. Justice King made the following points, which I think are really important and really summarise everything you really need to know. So the no order principle only applies between principal parties to financial remedy proceedings, so husband and wife. and does not apply to a person who's joined to the proceedings. The general CPR rule that costs follow the event again doesn't apply in family proceedings. But pursuant to CPR Part 44.2, subsection 4, in financial remedy proceedings, when dealing with third-party costs, the court has discretion as to whether costs are payable by a party, the amount of those costs, and when they are paid. So the judge has what we call a clean sheet, which was what was said by Mr. Justice Wilson in Baker and Rowe. So it's really a matter for the court. But often, if the fact that one party has been unsuccessful is generally taken into account and a decisive factor in the exercise of judge's discretion as to costs. But it's not a slam dunk. It won't be in all cases that you'll get all your costs back because you were successful in your argument, although that generally tends to be the case. There are cases where it won't happen, so it's not a guarantee.
It's not unusual for Aasha to quote these in correspondence either.
You.
I often read those letters and think, she's got a point. So how I'm going to get out of that one. Very rarely I do.
Well, on a delightful point of agreement, and given that we're now 9:20, I'd like to say thank you very much to our expert panel. Thank you, Aasha. Thank you, Mark, and thank you, Leisha, for coming today and talking with us about third-party interventions. This seminar will be available as a recording, which I understand is going to be sent by email. Thank you very much for joining us.